What medical and legal documents do I need to be prepared for the coronavirus? Hi, I'm Steven Silverman, your Miami, Florida estate planning attorney. We're now dealing with an unprecedented health crisis, which has affected all of us, regardless of who you are or how much money you have. We've received many calls from clients and potential clients who are worried and uncertain as to what they need to do to protect themselves and their families. Concerns about their health and incapacity all of a sudden are more urgent and important. Many clients have previously prepared their estate plan but are now looking to see if changes need to be made. Some callers have told us that they do not have any estate planning and want to know what they need to have in view of the coronavirus pandemic. There are at least 4 documents you should have as a minimum. We will cover those now. The 4 documents are 3 that concern your health and medical issues. The 4th document deals with your financial situation if you're unable to make a decision for yourself. The 4 documents are a durable power of attorney that covers your finances. The 3 medical documents are a healthcare power of attorney, a living will, and a Hipaa authorization. What is a durable power of attorney, and why would I want or need one, and why is it more important now than ever? The average person is usually not clear on what the term power of attorney means or the significance. Even for those that have one or have studied the document, it's not often clear exactly who serves what role and why. A durable power of attorney, which is also called the financial power of attorney, is a document that empowers another individual to carry on your financial affairs in the event you become disabled or incapacitated. Without a durable power of attorney, it may be necessary for one of your loved ones, including your wife or adult child, to petition a court to be appointed guardian in order to make decisions for you when you are incapacitated. This guardianship process is time-consuming, expensive, and often costing thousands of dollars, and it can be emotionally draining for your family. When you create a durable power of attorney, you give this duty to a trusted relative, loved one, friend, or professional to help ensure your financial matters are taken care of and your wishes are followed. Financial powers of attorney give the person the power to manage your money and assets. When you appoint another individual to make financial decisions on your behalf, that individual is called an agent. Most people choose their spouse or domestic partner, a trusted family friend, or family member. Since you're an adult, Florida law does not allow you to automatically be able to have anyone act for you. It requires that you must appoint them through the use of a financial power of attorney. What are the limits of the power of the agent? It helps to understand what is being asked of the agent under a power of attorney. A person appointed to the role becomes a representative of the principal's finances. In effect, they gain permission to step into the shoes of the principal and act on their behalf. You determine what their power and authority is. If you choose to have a limited power of attorney, though, the agent's power is very specific and restricted. Normally, their authority to act on your behalf is limited to the specific transaction or actions outlined in the limited power of attorney. An example would be executing a real estate deed on behalf of an out-of-town principal, for example. This kind of power of attorney offers stricter parameters on what the agent may do on behalf of the principal. What duty does the agent owe to you? Regardless of which power of attorney, agents must act as a fiduciary to the principal. This means the agent must operate in good faith, with the best interests of both the principal and their affairs in mind. When making any decisions, the agent is required to consider the choice the principal would make. Those who abuse their power in this role can be held liable for their actions. Should an agent need to act on behalf of the principal, it is important that the agent document everything they do. Documentation is the best way to answer any questions or challenges to the agent's actions. Agents should not commingle their finances with that of the principals. Who can establish a power of attorney? Generally, any individual over the age of majority and who is legally competent can establish a power of attorney. Who may act as an agent under a power of attorney? In general, an agent or attorney in fact may be anyone who is legally competent and over the age of majority. Most individuals select a close family member such as a spouse, a sibling, or an adult child, but any person such as a friend or a professional with an outstanding reputation for honesty would be ideal. Can I have more than one person named? You may appoint multiple agents to serve either simultaneously or separately. Appointing more than one agent to serve simultaneously can be problematic because if any one of the agents is unable to sign, actions may be delayed. Confusion and disagreement between simultaneously agents can also lead to inaction. Therefore, it is usually more prudent to appoint one individual as the primary agent and nominate additional individuals to serve as alternate agents if your first choice is unwilling or unable to serve. When is the power of attorney effective? Under a durable power of attorney, the benefits and responsibilities of being an agent under a power of attorney start as soon as the principal signs off. However, most principals do not expect an agent to use this tool unless they become incapacitated. What is a healthcare power of attorney? Sometimes this is also called a medical power of attorney, a healthcare proxy, or a healthcare surrogate, or durable power of attorney for healthcare. The law allows you to appoint someone to decide about medical treatment options if you lose the ability to decide for yourself. You can do this by using a healthcare power of attorney, where you designate the person or persons to make such decisions on your behalf. You can allow your health agent to decide about all health care or only certain treatments. You may also give your agents instructions that he or she has to follow. Your agent can then make sure that the healthcare professionals follow your wishes and can decide your wishes of how they apply as your medical condition changes. Hospitals, doctors, and other healthcare providers must follow your agent's decisions as if they were your own. What should you tell your agent about your health? You need to have a serious and honest conversation with your agent to help them understand your medical conditions and the goals and priorities for your health care, as well as your values you want your agent to follow in making decisions on your behalf. It's also important to provide information that is essential for your agent to know in order to make decisions regarding your care, preferably in writing. Doctors and healthcare providers, you should provide the name and contact information of the doctor you would like to be your attending physician, as well as any other healthcare providers you would like to have treat you if necessary. Likewise, if there's any physicians or providers you do not wish to treat you, you can also specify that information. Medical conditions. You should make sure your agent knows about your medical conditions and how that might affect your care. Treatment and medical history. Your medical history may be important, and if you've had surgeries or other medical procedures, let your agent know about this. Prescriptions and supplements. You should provide your agent with a list of all the supplements and prescriptions you take. If you want your agent to refuse or to authorize certain medicines, you need to make this clear. Allergies. If you have allergies, especially concerning medications or food, please provide a complete list. Religious preferences. It's very important to tell your agent about your religious values and wishes. These could affect your choice about the medical care you would like to receive, or if there are any medical or religious traditions or rites that you would like to observe or not to observe. What is a living will? A living will informs others what you prefer for medical treatment. Should you become permanently unconscious, terminally ill, or otherwise unable to make or communicate decisions regarding treatment. In conjunction with other estate planning tools, it can bring peace of mind and security while avoiding unnecessary expense and delay in the event of your future incapacity. The law requires that a doctor make an evaluation of your condition and the prognosis that there's essentially no chance of recovery and or no brain activity, and that you want to be left to pass without further medical intervention except to relieve pain. This is sometimes called an advance directive or a declaration. What's the difference between a living will and a healthcare power of attorney? The living will is where you make the medical decision to continue or discontinue medical treatment, as opposed to the healthcare power of attorney, where you name someone else to make that decision. What is a Hipaa authorization? The federal government passed the Federal Health Insurance Portability and Accountability Act of 1996, Hipaa, to provide guidelines to the healthcare industry for protecting your information and privacy. Some medical providers have refused to release information, even to spouses and adult children authorized by a healthcare power of attorney, on the grounds that Hipaa prohibits such releases. Therefore, as part of your incapacity planning, you should also sign a Hipaa authorization form that allows the release of your medical information to your agents, successor trustees, family, or any other individuals that you wish to designate. Do I need a Hipaa form for my child? If your child is a minor, this is not an issue, since parents as legal guardians have access to their children's medical information and are already the ones making most of the medical decisions as well as paying those expenses. However, when your child becomes 18 years old, he or she is no longer a minor. This means that hospitals and doctors' offices must safeguard the patient's information from everyone, including you, the parents. While it makes sense that they should be the person making decisions on their own medical treatment, this can raise problems for some young adults. Many 18-year-olds are still in high school, live at home, and have their expenses paid for by their parents. Although they may be an adult, their day-to-day lives look more like that of a child. Parents should have their children prepare the appropriate documentation to ensure their parents can access their medical records and discuss their medical care. This is accomplished through the use of a Hipaa authorization form by the child. With this form, the young adult can designate their parents or any individual to be their authorized recipient of their medical information. Executing this document can be incredibly helpful if there's a question about the young adult's care while the parent is paying the corresponding medical bills and dealing with the health insurance company. A properly executed Hipaa authorization form can also be beneficial in the event the young adult ends up in the hospital. Because hospitals do not want to be fined for violating Hipaa, most will err on the side of caution and refrain from discussing or disclosing any information to family members without the properly executed documentation. Without this exchange of information, families can feel out of control and the doctors may miss important family medical information. As a companion to the Hipaa authorization form, it's also important to have a healthcare power of attorney executed so that someone will have the authority to make medical decisions on behalf of the young adult if he or she is incapacitated. Without this document, the family may end up having to go to court in order to have someone appointed to make crucial medical decisions. Do I need a Hipaa form for my parents? Many of our clients are providing for their parents, especially with the virus affecting so many parents and elderly persons. You could have problems dealing with their medical care. It is important that just like a child, you may need to talk to their doctors and understand their medical condition. If there's parents with more than one child involved, the potential for a conflict exists and the doctors will only deal with whoever is the authorized person. You may be dealing with their various medical insurance policies, including Medicare, Medicaid, Medicare Assurance, or a supplemental insurance. You need to have them prepare all of the above documents. If they have a condition like Alzheimer's or dementia, they may either no longer be capable of making the decisions or may be heading for that situation. If you are their caregiver, your job is going to be very hard. as is, and you want to have the best likelihood of being able to handle their medical issues without having to open up a guardianship if that is feasible. I did my documents 5 years ago. Do I need to redo my documents? You should make sure that you and elderly or ill loved ones have current legal documents, including living wills, healthcare powers of attorney, Hipaa releases, powers of attorney, and wills. Documents that are old, 5 years or more, may be viewed as stale, and even though they are considered legally binding, they could be difficult to use. You should be certain that these documents reflect your current wishes. Due to the virus, every adult, but especially if you're over the age of 60 or if you have a chronic underlying condition, should immediately review their healthcare related documents, including their living will, healthcare power of attorney, and Hipaa release. You should have signed current documents in place that reflect your wishes. Your healthcare power of attorney and Hipaa should list an agent who's able and willing to act. It should also list several successors. If your document is old, if you've moved, or if older family members or friends are not well, you might need to revise the document and name new people. While these steps may be obvious to you at this very difficult time, it is important to address these. If you have elderly parents or other loved ones, be sure they do as well. You should have backed up electronically your medical documents and your durable power of attorney, but also should have printed copies of current documents prepared to take with you in case you're hospitalized. Having a PDF online is great, but having an envelope with photocopies of the signed documents might make it much easier to get through hospital admissions. Prepare a go bag if you have to go to the hospital without an advance planning. Have the go bag that includes copies of these documents, your insurance cards, and any other important paperwork so you don't have to try to locate these in an emergency. Thank you very much for listening to our presentation. If you have any questions, please feel free to contact our office. Our contact information is on the bottom screen.